Good afternoon, everyone. My name is Paul Hennessy. I am the head of the governance task force for KICA. And the purpose of business is to wish Shannon, our COO, a happy birthday. That was the important thing. Okay, so, and I think what we're going to do is we're going to have this session. I'm going to make some introductory remarks. We'll field any questions that are either here in the room or online. And then it's being recorded, and we'll make it available to community members who were not otherwise able to attend today. Okay, so the first thing I want to do, importantly, is to recognize and introduce the members of the task force. To my right, Glenn Thompson. To my left, Beverly Farrow, Amanda Moll to my immediate left, and further to the right, Andy Capelli. Importantly, Shannon and Ellen are both critical members of the effort, and I especially want to recognize them. We are advised by the association's legal counsel, Rosen Haygood, and they have been actively involved, and as we get closer to actual recommendations of the board, their involvement will accelerate. Our mission today is threefold. We want to do a little bit of explain, we want to listen and learn, and we're looking for ideas. Now, I should emphasize that those objectives, listen and learn, and ideas and suggestions doesn't end today. The message to the community will continue to be, we want to hear from you, we want you to be engaged, we want you to be informed, we think what we're doing makes sense, but we will continue our effort to outreach with the community. There is material online, and there are the actual amendment drafts. There is a red line version of the total association covenant document. And importantly, we have crafted FAQs relating to this process, these amendments in this process. We will be updating all of those documents. We don't anticipate major changes, but to the extent that we get a good idea or a good suggestion or a new question that we should have thought of ourselves, we will amend those documents so they will be available to the community. Okay, work is ongoing. The task force will meet at the end of this week to debrief in terms of what we have heard either in this session or otherwise, and how we want to proceed. And as I alluded, Rosen Haygood, our legal partner, will be working in parallel with us to specifically review the amendment drafts and respond to a series of questions that we have put to them that we think are important to the community relating to South Carolina law and otherwise. Okay, so that's sort of admin. I wanted to go through a very brief statement of the value proposition for each of our amendments. And by the way, at any point in this discussion, if other members of the task force want to chime in, you're now officially invited to do that. Okay, 11. What we are referring to as Amendment 11 eliminates the E-type member status, and in particular eliminates the right to appoint a board member, which has existed for a long time. But the sort of the flip side of that coin is we think at this point in the evolution of our membership, it's important that all our directors be elected by the members of the community. And fundamentally, this amendment will accomplish that. What we refer to as number 12 is an empowerment amendment, and it has to do with the anticipation that KICA will take over in some form and in some fashion the function that is currently discharged today by the ARB. And so we feel it's important that as that transition planning process proceeds, there is a parallel track to create an amendment to empower the association to exercise these powers. And we're going to be careful in our language to anticipate a parallel track with the transition effort. Beverly Bureau coincidentally is a member of the transition team, so we're getting good feedback from that aspect related to this amendment. But the ARB amendment is essentially vesting KICA with a parallel set of powers as to what exists in the general covenants today for the company. Now, we hope and expect that the transition of those powers and responsibilities will be consensual, and we're working hard in that direction. So that's number 12. Number 13. Number 13 is a little bit of an oddball. It relates to the rules and regulations of the association. 2017, 2018, there was an effort to pass an amendment relating to the enforcement of our rules and regulations. For lots of technical and non-technical reasons, that amendment, while approved by the members, was never enforced, reported properly with the state, so it's null and void. We do have, however, rules and regulations that have been properly recorded with the state and which we and our council believe are effective. Notwithstanding that, we think that this amendment 13 will clearly, unambiguously establish the authority of KICA through the board to make, amend, and modify rules and regulations as it feels are appropriate in the future. So this is really a certification, clarification amendment. And then lastly, number 14 is a bit of a potpourri. There's nomenclature, there are some administrative things in there. We've constructed we've drafted a construction clause that clarifies that South Carolina law will always be superior to our association documents. We've updated the notice provisions. So number 14 isn't really a governance amendment per se, it's more administrative. Okay, what we're referring to as number 15 doesn't exist. Number 15 is an effort which we are working on, but have not concluded, relative to ambiguity that exists in our documents relative to member, capital M member. And there are two aspects of this ambiguity. One relates to eligibility to serve on the board, and the other relates to other rights and privileges that attend to membership in the association. So we are going to undertake in the task force an effort to craft either the first part or the second part, which is more complex, or both, and do that in a time frame that we can add an amendment to the package that we will present to the board in November. Okay, timing. A couple of key dates. November 18th is now the date of the November board meeting, and we hope to provide to the community and the board a finished package of amendments for the board's approval, and that approval will be to present those draft documents to the community for their approval under the terms of the existing covenants. That process, assuming the board approves, that process will officially begin coincident with the next director election, which will take place mid-January to mid-February. And then if the amendments are passed 60 days later, they will be effective. Okay, that is really all I wanted to say by way of introduction. And I would welcome any comments anybody on the task force would like to make before we open it to the community. Okay, hearing none. We're here to listen, learn.
Just say not all at once.
I have a procedural question. Do you want to, how do you want to set this up? Do you want to go through each amendment and see whether we has to say on that amendment, or does that one person speak, or?
You know, Phil, I don't want to overly script this. So if you have questions or comments, any order that you would like, we're happy to listen. Again, for our purposes, the more specific, the better, but however you would like to provide your feedback would be fine with us.
Anything else to prevent anything this first of all, I've sent many emails both to the board and to the task force or you directly on a lot of these issues. And I apologize, I wasn't at the meeting 2 weeks ago or whatever it was, 3 weeks ago. Sort of another time when we got back from Europe, like 1 o'clock last night. My body's here, my mind is in somewhere in another country. But so a lot of the things that I have to say are probably already maybe been discussed, maybe addressed. I don't really know. So on the development board seat type E member, my first comment has always been, many of us have said this before to you all, that under the development agreement, there was a way to take care of that without going through this covenant change right away. And this is no reflection on the man. I will say up front, being on the bylaw committee with her for what, 1.5 years, we worked on. I totally learned a lot, appreciated, and really enjoyed working with you that time. So this is more about the functional issue of the type B member. So I don't know why we chose to wait to have a covenant change in order to take care of that issue when it could have easily dealt with under the development agreement.
Well, Phil, I mean, that's a reasonable question. Is something that the board, not the task force, the board spent time on and took advice from council, and the conclusion that the board came to that this approach was clearer, more certain, and more efficient than some form of legal effort, which would have an uncertain outcome. So we did address this issue, and our conclusion was that both in terms of probability and timing and effectiveness and cost, this was a much better way to go.
I guess now, well, we may be seeing it at the end of the day. One of the issues I think Amanda had raised at some point was that there were many other documents out there that had reference type B in there. I think the original draft just sort of had that caveat that every place else written is taken care of. But that's changed, obviously, because you can only control KICA documents. Do you still feel that there's other places out there where this may create a conflict or an issue?
Yeah, sorry, go ahead.
We did not identify any that would be of concern.
Okay, well, good, that's good.
Now, that having been said, the language in the amendment just refers to the KICA covenants.
Right.
It doesn't refer broadly to any other, unnamed document that might exist.
So that was, I think about to raise that as a, how does that work question? But so, how many of the common people? Victoria, I presume you're here as the board members, you're not commenting or?
I probably will comment.
Okay.
Moral support, Bill.
Yeah.
Yeah. Well, I know you've seen a lot of them. So moving on to the ARP issue, Amendment 12. I don't really have a lot to say about that other than, I've read this and I think comments made in the past and having a little more meat on the bones, explaining how the process is actually going to work. Because we all familiar with how the ARP currently works, to do something. And those functional details of how the new ARP, whatever scope and function it has, is going to operate, I think is imperative to understand in order to support or not support the transition.
Well, we have a couple of members of that task force transition team here, but what I would say is two things. First, my understanding is the transition team is working very hard to produce its next significant report to the community and the board in terms of how the transition will really unfold. But secondly, we also feel that as a matter of timing and efficiency, that it makes sense to clarify the authority of the association today, so that as and when that package, whatever it is, in whatever form it takes, is approved, presented to the community, discussed, approved by the board, etc., that we won't have to then start another very lengthy process to get an appropriate amendment in place. As you know, Phil, currently the association does have architectural powers, albeit of the common properties, which have never been exercised. This is really intending to craft something that is parallel, very similar to the powers that exist for the company today, in anticipation of a transition plan that is appropriately presented and approved ultimately by the board.
Well, and I know that's difficult to predict when that actually is going to happen. Is there a second report on yet, or?
Soon. Well, soon, we talked about this, it's being finalized.
Right, because I think that's going to have a lot more meat on bones of what's going to happen, but there's nothing in here which is understandable, so the covenant path says you have this authority, but there's no clear path when that authority will actually transition.
Well, so it's a good point, Bill. What we've tried to do is create language in the amendment itself such that the KICA board can, if I can use the term, operationalize the dimension or part or component of architectural review that is consistent with the strategic and operational transition plans that are being developed. So we don't anticipate that it'll be binary, day one, nothing, day two, everything. We do anticipate there will be some sort of a measured transition, which makes every sense in the world, as you can appreciate. But this is intending to be an enabling authority, regardless of the pace or timing or which pieces are turned on when.
Well,
Excuse me,
I'm
so
sorry.
if I just wanna make sure I understand your comment. So it sounds like you're not sure you can support this amendment because you're not sure what we're calling the KICA ARB might look like. And if you had an idea of what this KICA ARB might look like, then it'd be easier for you to support this amendment?
well, that's part of it, and that's correct. I think a lot of people probably feel that way. Everybody has their own personal experiences with ARBs, and I know ARB, and I know they've been plastered all over IKEA well at times, but the question becomes, so you create a covenant that says you have this ability to do this. And there's a teamwork group that Kevin's on, and that I think one of you gentlemen are on, that's creating a more detailed,
A template, a template,
a template of what that's going to look like.
right?
But that template, and you say soon, I think would support the ability, for folks that don't know these covenants, they really want to know what it's going to do and how it's going to operate. And without that information, many folks may have a question over what it's going to be. I've only had one experience with ARB over the years, I've been here, which is quite a long time. And I know other folks have had other experiences. So the question folks have is, what is this going to look like and how is it going to operate?
Right.
And that information is yet to come. So I think it's important for all that information to be in the public record in order for folks to support it.
That's the schedule. That is the schedule.
Right, well, I don't know what this is, man, it's kind of, the report's coming out soon.
Which one? I mean,
We elaborated on that in the board meeting yesterday. We're 95% done. We met with the ARB this week. We're waiting for feedback from them. We're gonna go back to the KICA board. We're gonna have a community meeting in November, and then we will finalize it before year end for the voting of this Thursday.
Okay, and I apologize if I didn't hear that yet. Somewhere over your mic. And I'm glad to hear all. I think that all should be articulated though very clearly in the documentation of the presentation, because not everybody goes to board meetings, not everybody listens to them. And since it's all related, I think those are details that need to be put in a forum where everybody can see them.
Right, and I'm not gonna sit here and say that you're wrong. I won't do that. But my perspective is, if for some reason the architecture for the association ARB isn't crafted and approved on the schedule that we hope and anticipate that it will be, it still makes sense to recognize that the community wants to have an ARB that is effective. You can't argue with the fact that the ARB and the professional aesthetic architectural standards that have been put in place for decades now have accrued to the benefit of all the property owners. And so that's number one. Number two, I think the community feels that we're mature enough and responsible enough and thoughtful enough that the association should be in charge of the architectural review board. Now, not everybody actually agrees with that statement, but that's sort of my perspective. So hopefully we will have the horse in front of the cart, but even if it turns out that that process is delayed, my own feeling is it would be appropriate for the association to have these powers approved by the membership, so that as and when an appropriate timing and action plan is approved and in place, we don't have to then have launch a new amendment process. That's just my perspective.
All right, that's all I'm saying is that, folks, when you're asking folks to vote yes or no on a covenant, they will want to know what all the details are, because that's the way now maybe other folks don't, I don't know.
FYI, this is one of the FAQs that we have addressed. And again, it sort of mirrors my perspective, but I understand your perspective.
Okay.
Yes, ma'am.
So I think I understand that you're just creating the power so that when the detailed plan is put in place, then at some point, 500. what's not clear to me yet is, has there been approval given that this transition actually going to happen? Or is that depending on the details?
Yes and no. So, Jordan Phillips, partner at South Street, KICA Partners, committed to transition at the, I believe it's the December town council meeting last year. So it has been a focus of the current ARB as well as the work group to formulate plans. We formulated a plan, they formulated one. We met yesterday to start trying to mesh what that means so that we can actually negotiate this and have agreements in place. So that process is happening, but it hasn't, it's not complete yet, so we don't have an actual transition plan that everyone's agreed to yet.
Yeah, KICA has not approved anything. We're writing the plan, we're taking public comment, and then we'll present it to KICA, and we'll hope that whatever plan is, KICA partners agrees with, or we negotiate to one.
And can you comment on what the sticking points are or may be?
We presented all our ideas, and they are coming back to us with thoughts on all those.
Right.
So, it's October, but do I think we'll be pretty darn close by December, and the vote's not until January? I think so. Is that fair? I mean, we've got a couple more months to talk about it. Well, these are the things.
Yeah, and I think we were closer than I thought we were.
Right.
And as far as the sticking point, there's.
Right. There are a few, but I think, it would be premature to even say that any of them are actual sticking points until we get feedback from the broader groups.
Discussion points.
Let's say we resolve all this in January 1st, and then we're not ready to take this vote, then we're like another 6 or 7 months. So there's really no pressure for us to resolve and keep partners. We can't take over for 6 or 7 months anyway. It becomes kind of circular exit.
And just another point, the transition isn't gonna be like flipping on a light switch, then one day you're going to the KICA ARB. It's gonna take several years to go through this transition process.
Right, and there's a lot of focus on how that's managed so that people know where they need to go to get review for what.
And we certainly are sensitive to the fact that this, meaning the ARB, is not a business that KICA is directly familiar with in a managerial sense. And, nobody wants to screw this up. We want a good plan. We want both a governance and an operational framework to be in place. And we want the managerial and budgetary analysis that needs to be done. So there's a lot of work to do. This is a piece.
Right, and I have no qualms with that, I absolutely believe in order to set up a functional, effective operating ARB, because it's going to take a little while. It's not something that can just happen overnight. Now, maybe it can be done in steps. Maybe that's a plan that's going to have different house coverage versus building a whole new house. So in my world, I always look to, when we have new rule development of any sort, we always have an administrative record to go with it that explains all these types of details. And we don't function that way here, but I think that's what would help folks understand. I don't think me as I'm just one person, but I just said that's my view of folks want to understand as much as possible before they want to sign on to a covenant change, because it's a huge difference. It's a huge difference.
We understand the point.
Rules and regulations. Number 13. I've been on the bylaw. We had that discussion multiple times about what happened in the fire covenant change and where it was, and feedback for several times. But I'm very familiar with the history of it. What I don't understand, and I know it was raised in yesterday's board meeting, is this idea of charging attorney's fees essentially for someone who even brings an issue to keep it. or issue is he can bring an issue to them. Usually charging attorney fees in the world is something that is considered a detriment to the public, because that means you have to pay for something before you defend yourself or your rights, or you even bring a challenge. And so why are we assessing attorney fees regardless of the outcome of whatever the issue is?
Well, I think, I'll let my colleagues answer it as well, but my thought was that if we are in a situation where there is a violation and the association believes that it needs to take action to cure this violation, and the violation continues, there has to be some ability to enforce. Otherwise, why have the rules and regulations in the first place? And in the extreme case, there are going to be costs that the association will incur to enforce provisions that are being resisted by the homeowner or whomever it might, the property owner, whomever, whatever the circumstance might be. So I think all we're saying is that the community will have the opportunity to recover its costs, including legal fees if there are any.
But you do understand that, in some situations, that's considered a chill on the parties involved in terms of their willingness to take action. Now, I know the question was asked yesterday, and that is, have we assessed fees? Have we done this where it's cost the community association money in the past for a covenant violation or, for some rule violation? And
Have we assessed fees?
I know we've assessed fees, but have we recovered attorney fees against the parties?
I don't know. I don't personally know the answer to that.
I don't remember if we recovered them, we certainly heard.
And do we have a sense of what the cost of those attorney fees are? I know you don't probably bring it down. I'm not.
But conceptually though, Bill, so I guess this situation could exist where there is a rogue board or there's a rogue KICA management team, and for some reason we're incurring costs and charging costs that are not appropriate or whatever. I guess theoretically that could happen, but I think it's extremely unlikely. As an example, and I didn't know this until recently, we've never actually had to enforce a lien. We've filed liens, but we've never actually had to enforce a lien, I think, in our history. So I think the association is a member association. So I think the risk of bad, capital B, behavior on the part of the association is relatively small. Is it possible? I guess it is theoretically possible, but more likely is that in order to enforce its rules for the benefit of all the community, there will be some costs involved. And if and when that is the case, it seems to me justifiable that the association be reimbursed for those costs.
So hypothetically, if you came after me because I parked my bikes in my driveway and I still haven't hidden, and you filed a lien against me for that, now I have to defend myself. So I have to hire a lawyer to defend myself. And if I win, even it's found that that's not really a violation that should be charged against the property, you can still collect attorney fees from.
Well, a couple of comments. First of all, in all cases, if you are being reprimanded or fined for a violation, you have an appeal right. And so I think that is not a trivial safety measure that has is specifically built in. And as a derivative of that, we've also included in the amendment certain extra protections for more severe penalties that they be approved in advance by the board of directors. So we're trying to be sensitive. On the other hand, with 45 or eventually 5,000 front doors, we're going to have some bad actors on the island. We know that. We've had firsthand experience with that. We've had homes that were derelict. We've had behavior at the sandcastle, which is dangerous. So we have to recognize that as a sizable community, we are going to have 2 Sigma events, and that's what this language needs to incorporate. So I hear you, but we're trying to provide the association with authority that is not inappropriate and is consistent with the past behavior, the past 45 years of behavior that we have seen. All under the oversight of the board.
All I'm suggesting is that you consider writing and drafting it so that if the party who's being accused of something prevails, that they don't get a separate attorney's fee.
That they would.
They do not get a separate attorney's fee for even bringing that action to begin with.
If they prevail on the act, if they prevail.
20 years to have to do that.
Okay, no problem. You're saying if they prevail, and you don't think, because right now it says may be a fact against the owner, and you don't think the language may is
Maybe
sufficient, too
Okay.
permissive, I mean, or it said
what
will,
we're basically saying is that, you know, so if you come after me for something,
right,
and I prevail, either in the initial or in the appeal, you can still assess attorney's fees against me for the cost that you've incurred for taking that action. And
so,
that doesn't protect homeowners.
Okay, so what you would like to see is some protection as and when you are deemed to be a non-offender.
Well, there's other ways to look at it too. In most cases, generally, at the end of the day, the judge will say, you know, fees are assessed to each party themselves. And I think something to protect the homeowners from being assessed fee, because for attorney fees for something that was found to be improper by improper enforcement. I mean, that's easy to fix. You just have to have a.
Yeah, say should KICA.
I'm just asking whether it's something that would be considered.
So if you have language either from other associations or free form that you'd like to suggest, we will absolutely consider it and consider it seriously.
I think what you're saying is that even the language here may be assessed if the owner prevails. Is basically what you're saying.
I tend not to negotiate that way. I like to look at it all right.
Well, send us something.
Oh, that was not sending something.
No. It's fine. We want that.
But is that, I think,
We want that because we want the members to vote for it.
correct. And I agree, I think that's, you know, one of the problems you're gonna have is you have to have a huge threshold if this thing is approved.
Huge.
And so all it's gonna take is somebody complaining about that publicly or whatever, and then you end up with.
All right, what else?
So we've had this conversation a number of times at the committee, but going back to basically the first meeting that I recall. But more importantly, in this way, of course, you had the same action you had with the ARB response. There is a task force now working on a complete revision of the rules and regs. And there may be, and I'm not gonna comment, I have no idea what they're doing, except that they're working on it. Sharon might give you a better response in terms of timing, but there may be some distinction in the rules that apply to issues where legal fees might be incurred or don't need to be incurred. And it would separate and make those kinds of violations different than all the others. So it's possible that the issues you were relating to, the parking violation might not even be subject to a lien or anything else. So, but you gotta wait and see what comes out.
Well, yeah, that's a good point, because you all aren't gonna have an attorney involved in everything that happens. Now, there's a lien filed, it's going to have an attorney involved. But if it's just an assessment of some sort, there may be, you know, maybe a threshold that you have to establish to do that, but I think everybody understands my concern, and there's some.
We understand your concern, and if you have a specific recommendation, again, either that you created or somebody else created, we're willing and able to review that. Yes, ma'am.
Two questions. I'm not looking at the very but it feels like the biggest thing that there's an amendment is the appeal process in the board and the side. Is that a fair summary of what I'm hearing?
Well, in the existing rules and regulations, there is an appeal process. The board provides the oversight associated with the appeals. Our conclusion was, initially, we didn't try to deal with the due process issues in the covenant itself. I said, no, that'll be when the rules and regulations are revised, they'll have all of the due process protections. We changed our mind based on input that we received, that there should be specific reference to member protections. And we added to that this specific approval function for the board for the most serious sanctions, including, for example, the filing of a lien or suspension of voting rights or use of common properties. So we've included, even though our initial predilection was to leave that to the rulemaking process, we felt it was appropriate to put those protections into the amendment itself.
Okay, so this amendment right now is to delineate the range of actions where the rule document is actually stuff.
Right, parking, whatever, in great detail. And in fact, if you go to the extant rules and regulations, is quite detailed. And so, as was mentioned by Andy, that process of, top to bottom review of the rules and regulations has started. It's starting appropriately with staff, and eventually it will make its way up to and require approval of the board. But that is a level of detail that we didn't want to and feel really shouldn't be embedded in an amendment.
One follow-up, this is just based on comments I sent back in July. If you go to the KICA webpage, there are rules and regulations in there. I know in the past couple of years, the board has gone in and deleted a whole lot of extraneous things that are on the website that probably need to, there were so many different rules out there, but there is a specific handbook of frequently encountered rules and regulations that was adopted by the board in 1990, and there were revisions approved, adopted in 2018. So it still exists out there. I would recommend something in this to basically say that any prior existing rules and regulations are no longer effective, or are you going to do that when you actually establish these rules and regulations?
So I think that's an important point, Phil. We believe, and we have taken counsel on this, that the rules and regulations which have been filed with the county appropriately, are effective. And so what we're trying to do is solidify and remove any ambiguity associated with the prior failed amendment process. So, we're not concerned relative to the, effectiveness of the current rules and regulations. We want to underpin them with this approval so that any issue going back to the prior effort, which was unsuccessful, is made officially null and void.
Well, and I'd love to see what Frank said about that, because one of the concerns I have is on the webpage when it's written, is that it's not intended to be all encompassing and inclusive of all rules and regulations. So you have this document that is supposed to be the rules and regulations, but it's not encompassing of every rule and regulation. And you want to enforce that, I think you're gonna have a real problem there. And I understand it. And we talked about it. There's so many messages of old things on, and every time you look, you'll find something else.
Right, and that's why, Phil, again, just for purposes of emphasis, that's why we felt that a detailed compilation of rules and regulations doesn't belong in an amendment, because the amendment process is so difficult. There has to be some level of trust in the competency and good faith of the board. And if that doesn't exist, that's a much bigger problem that the association has. But we acknowledge that the rules and regulations need to be updated. We know there are flaws and gaps that need to be corrected, and that's been officially recognized and is in process.
Okay, number 14, I really don't have any comments. There was a lot of, I sent some earlier messages and some little bits and tweets that need to be changed, and I think you probably addressed them all. I haven't looked at it in detail, but, there's always going to be a typo somewhere, but you have to do it.
The one thing that in my introductory comments, I failed to mention is that we have heard from a number of members in the community that the amendment process needs to take a comprehensive look at the governing documents of the association. And our conclusion was that view is correct. But we also believe that the amendments that we're proposing are good for the association, are time sensitive for the association, and are good for members, and are a step in the right direction. The comprehensive review of our documents is a big effort. It's a big effort on two levels. Technical level in terms of ambiguities, contradictions, potential variances from current South Carolina Not-for-Profit Act law, and then the even more challenging level is the sort of principal issues, LE principal issues that are embedded in our documents relating to quorum, relating to all sorts of issues that have existed for 45 years and maybe aren't reflective of the way the association should be managed today. So we're going to undertake a broader review of the association documents. We're going to create a process. We're going to put a budget on that process, but that's not going to happen near term. That's going to require a lot of work, but we do agree that it's necessary. And we do not believe that proceeding with these amendments is injurious to that objective.
If I can raise that, so I'm going to raise a couple of points now in the duty. Not to mention number 15, which I'll talk about in a second. The future 15. bylaws task force, our initial, as you guys were writing, I don't know if the task force members see the emails that we send to the board asking a lot of those questions. Because when we were tasked, our job was to go through the entire bylaws and the entire code. And as Amanda will remember, we initially started that way and we realized, oh my God, there's no way we can do this. We need to do it in an iterative fashion. And one of the things I did, I was tasked with, was create a crosswalk. State Act, Covenant, bylaw, so you can compare them all directly. And we fully anticipated that we were going to get to the covenant once we were fully done with the bylaw. And so that's why it was so surprising to many of us that who were under that understanding that that was the mandate from the board at that time, that all of a sudden we switched and focused on a certain number of amendments when there was really a need and argument for a comprehensive review of the covenant. Because I think you'll find when you get into the details, there are a lot of things that the covenant that just need to be addressed. And that's why I personally believe taking the time to do it all at once, asking all the members to vote on a covenant change to comprehensive, rather than getting up there and saying, we're going to change these, but we're going to come back to next year with more, and next year with more, and we're going to keep moving forward.
Well, again,
That's a choice.
it is a choice, and I appreciate the point of view. We think the covenants that are being presented here are good for the community, and are significant. When and as we take do a broader analysis of the governing documents, we're going to find things that are not just technical, but what about the quorum requirements? Okay, they're very high. Are they appropriate? It's not a legal issue. It's not a technical issue. It's a judgmental issue in terms of what's appropriate for this association for the next 50 years, forgetting for a moment what we had for the last 50 years. So that's the kind of undertaking that we're talking about, and it involves best practices. As an example, if there are other large complex associations across the country, how have they tackled issues? There are limitations on assessments. Do those make sense 50 years later? There is a lot of work and analysis that has to take place just to identify those issues. And so we're probably not talking about months here.
We never expected that.
But meanwhile, I think the association says, no, we want to support the transition of the ARB. We want to deal with the e-member. We want to make sure that there is adequate enforcement of our rules and regulations. We didn't dream this stuff up. It was based on pretty regular feedback through formal and informal communications that the association has had. So look at it. I raised it because it's important, not only because we've gotten some feedback on it, but we think it's important, but it's a big lift and it has to be well organized and thoughtfully undertaken. And we're going to try to make that happen. I can't begin to estimate when we'll have an operational plan for that, but we agree.
I think there are a number of things in covenants that will need to be addressed. I don't think it's as daunting as some folks think.
I hope you're right.
The last thing I want to raise, and I raised it in an email to the board yesterday, and I raised it before in the board meeting, when advice is given by counsel responding to questions. So this all started, you had posed the questions to the law firm, and they gave you a response. And you had suggested we were going to get to see that response. Then all of a sudden it came out and said, no, we're not going to share the response with you. And subsequent to that, you mentioned today that there was an opinion given by them on one of the issues, I can't remember which one. But there's been a number of queries to the law firm that resulted in written comments back to you all, I presume, I'm not sure how they was transmitted. And to me, under our existing rules, the regulations, those are considered KICA records. And they're public records that should be shared. I know we've had a conversation before, but they're not subject to any privilege that I, as a lawyer in South Carolina, are aware of. So why can't we see those? Those are part of the administrative records supporting your decision. And we really need to understand what perspective you're getting in making these decisions.
Well, a couple of things. That list of questions, we've asked council to update their feedback on the questions. Not all will be in the form of a formal opinion, some may be in the form of a formal opinion. And they will be discussed with the board. It is a complex issue, Bill. We want to be transparent with the community. We're not interested in hiding anything from the community. On the other hand, when we ask our council for guidance, advice, and opinion, capital O opinion, we want to be careful that we get the best advice possible. And there could be, I can envision circumstances where we get advice from council that says, okay, here's our opinion. It's a should opinion. It's a more likely than not opinion. And here are all the risks. It may or may not be in the interest of the association to have that kind of an opinion published. If there are opinions or guidance that we can release to the community without violating that longstanding principle of the board, we'll consider that. But this is something that the board has. This is not something that we here can decide. That's something that the board will have to discuss.
A couple of points, and I'm not trying to be argumentative. First of all, the question is, under what legal authority are you withholding that information? Number one. Number two, if I was the person asking the question with Frank, and we did this before the bylaw, we would ask the question in a manner and have them understand and expect that their response will be made public as part of the record to support our decision making. But what is the legal basis for withholding those documents? They're KICA records.
Well, I guess I would, being a non-attorney, it's easy for me to say this, but I would turn it around and say, on what basis is it a requirement to disclose legal opinions?
It's not a question whether it's a legal opinion, it's a question of whether it's a KICA record, which under the existing rules and regulations.
Let's get somebody who's more knowledgeable.
I'm going to quote one. Okay. The bylaw said, files and records of an attorney who performs services for the association, and the association, not their members, are not records of the association, when for the association are not records of the association and are not subject to the inspection of members.
If they're done for an attorney-based purpose, that's not the thing. If you're asking to interpret regulations, I don't write that, Kevin, so I know what it means.
Okay. So could I make a suggestion? Look at, I appreciate your feedback. I think we understand this issue. We will consider it, but I think we get your point. But I don't want to mislead you. There is a longstanding practice, and I'm not suggesting that we're gonna change that practice. We'll talk about it. We'll think about it. We'll talk to council about it. But I'm not gonna make any inappropriate promises.
Right, well, just to be clear, when you're asking an attorney for advice in the conflict of litigation, those are considered, protected executive documents. When you're just asking them an opinion of how does this regulation read, what does it mean, how do we interpret that, those are different. And I do think I think by not sharing those with the members, especially when it was promised that they would be shared at one point, and then later said, no, we're not going to give you their comment. I don't think that's really helping your process in terms of fully understanding how these decisions are made. And it's going to become critical when you're talking about the member issue.
Yeah.
Without question.
Okay, thank you.
You should, watch the video tomorrow. We talked about,
Starting
tomorrow or yesterday, the first part of the meeting is on the member issue. You may want to just put it back to that.
I was going to, 1 o'clock last night, it's not on my agenda.
Okay,
And this morning, I don't think I would have understood it anyway.
any other comments or questions?
So you were gonna talk about 15,
I'm sorry.
potential 15 you were gonna talk about?
Well, I don't know, there's not enough flesh on the bones of that, I mean, we know what the idea is, and I've written comments, a lot of us have written comments about how you define members, especially in light of the way the state act is written about natural persons for directors and all the different definitions that are out there. These issues that are raised in fairly extensive detail to the board, and I'm not heard anything back other than now you're saying that you're gonna look into that. So, Andy, if you haven't seen the emails that have been sent to the board by Tim and others, I think that would be in your interest to see.
One of the things I'd point out is one full outline an approach with thinking about taking here for the covenant amendments. My question really is, what is the approach that the board took in doing, the committee took in revising the bylaws? Because that really becomes a bylaw issue.
You said, again, I'm sorry, I never heard.
When Paul outlined what we're doing on potential 15,
Right.
he pointed out the approach we're gonna use doesn't deal with the entire issue of vote a member. And one way to proceed, which we're gonna do, is to try to solve that problem with respect to the ability to serve on the board. As far as the other issues that affect both the member, or the ability of the member to do whatever, we're not going into that. Well, my question to you is, what, if anything, did the bylaws committee do to deal with that issue? The broader issue.
The bylaw, we anticipated it was a member issue without understanding or realizing the ramifications of all of it. And nobody at that time knew or thought about the issue of trusts and LLCs and other non-entities. That was just not on our radar. The reason we changed the bylaws and wrote what we wrote was knowing that there's this definition of members that needs to be addressed more globally. And we were trying to address the specific issue when it came to board members and how those members, who could be a member. Now, there is several layers to this whole issue when it comes to membership. And then above that, members or what members can be directors. Those are two different levels. And I would encourage those to be addressed.
So,
And
again,
you haven't,
let me just, in the interest of everyone's time, we recognize that there are multiple levels here relative to the member issue. It's eligibility to serve on the board, and then in Maura McIlvain's terms, the bundle of rights in addition to that. So we get that. We're gonna look at both. If there's an improvement that we can craft in a timely fashion for one or the other, we're gonna do that. We'll propose that to the board.
well, no, I think that's what everybody's agreeing.
Okay, so I think we're violently agreeing.
Finally,
Ellen, do we have any hands raised?
No?
All right. Thank you for coming.